The first is with respect to the gag order as it relates to Ms. Daniels. We ask that President Trump be allowed to respond publicly to what happened in court the past day and a half, and this will tie into the motion that I'm about to make for a mistrial. But the press reporting over the past 24 hours about what? About the current version of the story that we believe is completely false, and that President Trump has said is completely false since the first time it has been mentioned, is completely different in kind than the denials and the story that has come forward as far back as 2011, as 2018. And it is significant because, for example, on the news last night there was, and this is just one example, and there are many, one of the supposed participants in that evening, the friend of Ms. Daniels who supposedly was returned, she got a phone call from the room that there was testimony about.
Yes.
She was on television last night talking about what happened and also corroborating what Ms. Daniels said. This was on a political show with political commentators, then commenting about the seriousness of, again, this new false allegation, right? So it's not. This isn't President Trump again being able to say this never happened. This isn't true. It's now him having to not be able to respond to this new version of events that now deals very deeply with a very different issue than a sexual event that took place in 2006. And so, as we said repeatedly, and I'm not going to dwell on it, but, this is about he needs an opportunity to respond to the American people. And the reasons for the gag order as they relate to Ms. Daniels are over. She's no longer a witness. And as it relates to other witnesses in the case, Your Honor, we are towards the end of the case. I can be corrected by the people, but I believe that the only significant witness left, that's the wrong word, the only witness that is really the subject of the gag order is Mr. Cohen. And so, as far as the court's concern about this proceeding, it should give way to the testimony of the past couple of days. I mean, he's going to be asked repeatedly over the next week or two about these new accusations of consent and of what happened that night. And as the gag order stands now, he's not allowed to say, I did not do that. So there are voters out there and there are questioners who will ask him questions about it and he can't say anything. The other side can say things, and they already have. There are numerous news articles about it, many articles, Your Honor, today, just based on yesterday, indicating. I haven't checked the news today, but there is no doubt that there will be a feature of political shows tonight and articles. And it cannot be that he cannot respond to that, Your Honor, now that she's off the stand, especially because this isn't just the same story that has been going around for the past several years. It's much different. And so we would ask that he be removed from the gag order as it relates to Ms. Daniels, and that he be able to respond.
All right, let me hear from the people.
Thank you, Judge. And it seems as though the other side lives in almost an alternate reality. First of all, there is not another side out there. There is a proceeding here that this order is designed to protect, and I think it has been somewhat effective thus far. And I think we have to look back as to why it was issued in the first place. To put in context, what's going on here? This order was issued to protect the witnesses, the citizens participating as jurors, all the people participating in this proceeding, and the very proceeding itself. This is where facts are brought out. This is where, if somebody wants to respond to something that's said in this room, that can happen in this room. It's not supposed to happen out there. There are people out there saying things about Ms. Daniels and other witnesses, clearly saying them with the defendant in mind. I'm not in a position to say that it's at his direction or anything close to that, but there are people making the defendant's case for him out in the world. We have been told repeatedly by witnesses, even in the courtroom, even on the stand, we have seen the fear in some of these witnesses. The witness who just testified a couple of times broke in because there was an exhibit displayed on the screen that had her home address. And you could see the fear in her eyes when that happened. It was luckily not displayed to the public, and that's because of what this defendant is doing. It's what he has done in the past. It's why this order was issued. The order was not issued lightly. It was issued after we developed an extensive record relating to the attacks this defendant mounts indiscriminately for anyone that he deems worthy of his venom. He does it selfishly, with no concern about the safety of the people he is attacking, and, unfortunately, we have seen the results. Among the evidence the people submitted in a room that formed the basis of the two orders restricting extrajudicial statements was evidence of the significant safety consequences of the defendant's public attacks. We submitted an affidavit from the head of the Danny, the DA's Office Executive Protective Detail about the explosion and threat cases lodged by the NYPD against the DA, his family, members of the prosecution, their families. Your Honor has seen firsthand, as I talked about the very real consequences for witnesses when they express fear in the courtroom. I had a conversation with a witness last night, a custodial witness, somebody who is coming in to put in records, who is concerned about safety, and that's not the only witness like that. They are not witnesses who have a huge stake in this, and they are worried about it. The fact that witnesses are brave enough to come in here, under subpoena, tell the truth under oath, shouldn't expose them to this defendant's barrage of threats that will put them, and potentially their families, in danger. Modifying this gag order now, in the middle of trial, would signal to future witnesses that they could be at risk as well. In affirming the D.C. Court's gag order in the D.C. criminal case, the D.C. Circuit relied on exactly this point. That court held, and I quote here, "Common sense and common human experience teach that hostile messages regarding evidentiary cooperation that publicly relate to high-profile witnesses have a significant likelihood of deterring, chilling, or altering the involvement of other witnesses in the case itself." The undertow generated by such statements does not stop with the named individual. It is also highly likely to influence other witnesses. Here we have other witnesses. We have a jury. This is a proceeding that's going on. Some of these orders have involved proceedings where we weren't even on trial yet. Here we are on trial. This order is not designed just to protect the witness until they are done on the stand and then they walk out the door and they have no protection. And it's not just designed to protect the proceeding part of the way. I also just wanted to point out, we saw a quote from this defendant an hour and a half ago that sort of addressed that exact point. He said, "You attack people because other people see you doing it, and it sends a message." That's his words on that screen today, and that's what he's doing here. Modifying the gag order now to allow the defendant to attack Ms. Daniels, and that's what he wants to do. Let's not pretend he wants to engage in high-minded discourse, and to thereby put her at risk would see Iosley risk jeopardizing the integrity of these proceedings. We understand. Well, I will leave it there. Thank you.
All right.
I mean, Judge, just briefly, everything that you just heard is different in kind from our request. We're not talking about all kinds of threats that witnesses may be hearing from others besides President Trump, or a witness's concern for her safety testifying, or his safety testifying in this environment, which is understandable, having nothing to do with President Trump. What we're saying is that in this case, on a narrowly tailored gag order, the court should constantly be making sure that its terms should remain in effect. And you have Ms. Daniels, who came in here yesterday and today, and was allowed to talk about a completely different version of events. And yes, we discredited her, and I am going to turn to that in a minute.
When you are saying a completely different set of events, what specifically are you referring to?
Your Honor, there are several.
Look, just give me the main one.
I will give a handful. So, for example, she testified at transcript page 2610 yesterday about the incident, where she said, "At first I was just startled, like jump scared. I wasn't expecting someone to be there. He's essentially minus a lot of clothing. That's when I had this moment where I felt the room spin in slow motion. I felt the blood basically leaving my hands and my feet, and almost like if you stand up too fast and everything kind of spins, that happened too. Then I just thought, oh my God, what did I misread to get here? Because the intention was pretty clear. Now, what she had previously said, and again, now I'm getting more to the mistrial motion, but the only reason why her testimony was admissible, according to the court's ruling prior to trial, was to President Trump's motive and intent, the co-conspirators' motive and intent, and what they knew at the time. So their motive and intent was based off of, among the articles and what she was saying publicly at the time, which is that, oh, here we go, we started kissing. I hope he doesn't try to pay me. Okay.
So I don't understand how that's a different alternate set of facts.
One is about consent and one is not, Your Honor. I mean, that's the issue, Your Honor. One is about...
Right. So there is some crossover between this and the motion for a mistrial. I'm trying to keep it narrow. I'm trying to deal with just one issue at a time. I know that there will be crossover. So let me address this first issue, and then I will hear you on the second one.
Understood. Another example of something that we heard on the stand today, but is not part of what was previously said about this incident and what happened next. Briefly, this is transcript page 2611 to 12. I just think I blacked out. I was not drugged. I never insinuated that I was on drugs. I was not drunk. I never said anything of that sort. I just don't remember. And then, very shortly later, transcript page 2613.
I'm going to stop you just in the interest of time. You will be able to make your arguments for the motion for a mistrial. I want to stick, again, just to this first issue. I don't see what you are referring to as a new set of facts, as a new theory of the case. Please have a seat.
Yes, Your Honor.
Look, in response to your request that modify the gag order so that your client can respond to Ms. Daniels, it's interesting what Mr. Conroy said because I actually wrote the same thing down when I was reading that portion of the book. My concern is not just with protecting Ms. Daniels or a witness who has already testified. My concern is with protecting the integrity of these proceedings as a whole. That means that everybody sees what happens. Witnesses who have not yet testified will see what happens. They will see how witnesses who have testified are going to be treated by your client. So the portion that I wrote down was where your client is attributed with saying, because other people will see you doing it. And that's my concern. Other witnesses, including not only Michael Cohen, but these other witnesses that Mr. Conroy referred to, will see your client doing whatever it is that he intends to do. And I can't take your word for it that, no, this is going to be low-key, this is not going to be an attack, this is just going to be a response to what was said, because that's just not the track record. The reason why the gag order is in place to begin with is precisely because of the nature of these attacks. The vitriol, these were very real, very threatening attacks on potential witnesses. So the track record, your client's track record, speaks for itself. I can't take your word for it that he will just say, hey, I dispute the facts. Now, I continue to be concerned about the witnesses using the gag order as a sword instead of a shield. And I will continue to be mindful of that. And I will continue to keep an eye out for that. But that's not what I see happening here right now. And that's not the argument that I see you making. So with regard to your application for me to modify the gag order to allow your client to respond to Ms. Daniels, that application is denied.